India, a land of immense natural beauty and diverse ecosystems, has a long history intertwined with its environment. From the towering Himalayas to the sprawling coastal plains, nature has shaped its culture, economy, and way of life for millennia. However, the path of development and a growing population began to exert unprecedented pressure on these precious natural resources. Recognizing the urgent need to protect its rich environmental heritage for future generations, India embarked on a significant legislative journey in the latter half of the 20th century. This period saw the birth of several key laws designed to conserve forests, protect wildlife, and ensure the purity of its water bodies, forming the bedrock of the nation's environmental governance. These laws were not merely symbolic gestures. They represented a profound shift in how the country viewed its relationship with the natural world. It was an acknowledgement that unchecked exploitation would lead to irreversible damage, impacting not just the flora and fauna, but also the well-being of its people. The establishment of a robust legal framework was seen as essential to balance the demands of progress with the imperative of conservation. These foundational statutes aim to create systems, define responsibilities, and impose penalties to deter harmful activities. They sought to bring a measure of order and foresight into the often chaotic interface between human activity and the environment, setting a new course for sustainable development. The significance of these environmental laws extends far beyond the mere words written in legal texts. They have shaped policy decisions, influenced judicial pronouncements, and empowered citizens and organizations to advocate for environmental protection. Understanding these laws, their origins, their objectives, and their mechanisms is crucial for anyone interested in India's environmental journey. They provide a window into the challenges faced by the nation and the efforts made to address them. This essay will delve into three such pivotal pieces of legislation: the Forest Conservation Act of 1980, the Wildlife Protection Act of 1972, and the Water, Prevention and Control of Pollution Act of 1974, exploring their core tenets and lasting impact. These acts, while distinct in their specific focus, are interconnected in their broader goal of safeguarding India's ecological integrity. Forests are habitats for wildlife, and clean water is essential for both, therefore. The effectiveness of one often relies on the successful implementation of the others. This interconnectedness highlights the holistic approach that India began to adopt towards environmental management. The journey has not been without its difficulties, and enforcement remains a constant challenge. Nevertheless, these laws represent a formal commitment by the Indian state to act as a custodian of its natural inheritance, a commitment whose importance only grows with time as environmental concerns become increasingly global and acute. The early decades following India's independence in 1947 were primarily focused on nation-building, industrialization, and agricultural self-sufficiency. While these were critical goals, the environmental consequences of rapid development were not always at the forefront of policy considerations. Large-scale projects such as dams and factories were undertaken with an emphasis on economic output, sometimes leading to deforestation and pollution. The prevailing belief was that the environment was a limitless resource capable of absorbing the impacts of human progress. This perspective, common globally at the time, began to change as the tangible effects of environmental degradation became increasingly apparent across the Indian subcontinent. A growing awareness, both domestically and internationally, started to emerge regarding the finite nature of natural resources and the delicate balance of ecosystems. The Stockholm Conference on the Human Environment in 1972, in which India played a significant role, was a major catalyst. It highlighted the urgent need for international cooperation and national action to address environmental problems. Within India, voices from various quarters, scientists, activists, and concerned citizens began to raise alarms about dwindling forests, declining wildlife populations, and the increasing contamination of rivers. These concerns were not merely aesthetic, they were deeply connected to livelihoods, public health, and the long-term sustainability of the nation's development. The need for comprehensive and uniform environmental legislation became undeniable. Prior to the 1970s, environmental protection was often addressed through scattered provisions in existing laws, which proved inadequate to tackle the scale and complexity of the emerging challenges. Different states had their own regulations, leading to inconsistencies and difficulties in enforcement, particularly for issues that transcended state boundaries, such as river pollution or wildlife migration. This fragmented approach highlighted the necessity for strong central laws that could provide a unified framework and ensure a more coordinated response to the growing environmental crisis that was beginning to take shape across the country. This period of awakening set the stage for the enactment of landmark environmental laws. It was a time when the nation began to formally acknowledge its responsibility towards the environment. The discourse shifted from viewing nature solely as a resource to be exploited to recognizing its intrinsic value and the critical services it provides. The laws that emerged from this era were a direct response to this evolving understanding, aiming to institutionalize environmental protection within the fabric of India's governance. They were ambitious, seeking to regulate activities that had previously gone unchecked and to establish new norms for the interaction between human society and the natural world. The Forest Conservation Act of 1980 was a landmark piece of legislation specifically designed to address the alarming rate of deforestation India was experiencing. Prior to this act, the diversion of forest land for non-forest purposes, such as agriculture, industry, or infrastructure projects, was relatively easier and often occurred without adequate scrutiny of its ecological consequences. The Act sought to put a stop to this indiscriminate conversion of forests. A key aspect was how it approached the term forest. While earlier definitions might have been more varied or limited, this Act, particularly through subsequent judicial interpretations like the Godavarman case, broadened the understanding of forest to include not just government-notified forests, but any land recorded as forest in government records, irrespective of ownership, and even areas that conform to the dictionary meaning of forest. This broader definition was crucial for extending protection to vast tracts of wooded areas that might have otherwise fallen through legal loopholes. The primary emphasis of the Forest Conservation Act was not just on preserving trees, but on conserving the entire forest ecosystem. This meant recognizing forests as complex, living systems that provide a multitude of ecological services, including harboring biodiversity, regulating water cycles, preventing soil erosion, and sequestering carbon. The Act implicitly understood that the loss of forests meant the loss of these vital services, which have profound implications for environmental stability and human well-being. It aimed to ensure that decisions regarding forest land use were taken with a full appreciation of these ecological values. The Act's main goals were therefore twofold. Firstly, to strictly regulate the de-reservation of forests or the use of forest land for non-forest purposes, and secondly, to provide for the conservation of forests and the myriad life forms they support. It aimed to halt the trend of rapid deforestation that was leading to habitat loss, endangering wildlife, and exacerbating problems like soil degradation and climate change. By centralizing the decision-making process for forest diversion, the Act intended to introduce a higher level of scrutiny and ensure that such diversions were permitted only when absolutely necessary and after careful consideration of the environmental impact. This was a significant shift from previous practices. The underlying philosophy of the Act was to treat forests as a national asset, essential for the ecological security of the country. It underscored the principle that forests were not just sources of timber or land for expansion, but critical components of the nation's natural heritage. This perspective was vital in shaping a more conservation-oriented approach to forest management. The Act sought to ensure that short-term economic gains did not overshadow the long-term ecological and social benefits provided by healthy forest ecosystems. This marked a pivotal moment in India's efforts to protect its green cover, placing conservation at the heart of forest governance and policy. One of the most significant features of the Forest Conservation Act, 1980, was the vesting of power in the central government to regulate the diversion of forest land. Prior to this, state governments had considerable autonomy in such matters. The Act mandated that no state government or other authority could de-reserve any reserve forest or use forest land for any non-forest purpose without the prior approval of the central government. This centralization was intended to curb arbitrary decisions at the state level and ensure a uniform national policy on forest conservation. It introduced a crucial check and balance, making it more difficult to convert forest land for other uses without compelling reasons and thorough ecological assessment. To aid the central government in its decision-making process, the Act provided for the constitution of an advisory committee. This committee, typically comprising experts in forestry and related fields, was tasked with examining proposals for forest diversion and advising the government on whether approval should be granted. The inclusion of expert advice was meant to ensure that decisions were based on scientific understanding and ecological considerations, rather than purely administrative or political expediency. This mechanism aimed to bring a degree of objectivity and technical rigor to the process of evaluating requests for the use of forest land, thereby strengthening the conservation mandate of the legislation. The Act also laid down penalties for contravention of its provisions. Any unauthorized dereservation of forests or use of forest land for non-forest purposes could attract legal action, including imprisonment and fines. These penal provisions were intended to act as a deterrent against illegal activities and to underscore the seriousness with which the government viewed violations of forest conservation norms. While the effectiveness of penalties often depends on robust enforcement, their inclusion in the Act signified a clear intent to hold individuals and authorities accountable for actions detrimental to forest ecosystems. This was a critical step towards ensuring compliance with the new conservation regime. The impact of the Forest Conservation Act 1980 on curbing deforestation has been widely acknowledged, although challenges in its implementation persist. It significantly slowed down the rate at which forest land was being diverted for non-forest uses. By making the process more stringent and requiring central approval, it forced project proponents and state governments to consider alternatives and incorporate mitigation measures. The Act has been instrumental in safeguarding vast areas of forest land that might otherwise have been lost. It remains a cornerstone of India's forest protection strategy, continually evolving through judicial interpretations and amendments to address new challenges in the ongoing effort to conserve the nation's invaluable forest wealth. Section 5, the Wildlife Protection Act 1972, a sanctuary for India's creatures. The Wildlife Protection Act of 1972 emerged from a growing realization of the severe threats facing India's diverse fauna. Before its enactment, wildlife protection was largely governed by disparate state-level laws, which were often inadequate to address the scale of poaching and habitat destruction occurring across the country. There was an urgent need for a comprehensive, uniform national law that could provide robust protection to endangered species and their habitats. The alarming decline in populations of iconic animals like the tiger, lion, and elephant, driven by illegal hunting and trade, underscored the necessity for strong legal measures to safeguard India's rich biodiversity before it was too late. One of the primary reasons for the Act was the need to establish a system of protected areas. This included the creation and management of national parks and wildlife sanctuaries, dedicated zones where wildlife could thrive with minimal human interference. These protected areas were envisioned as havens for biodiversity, crucial for the long-term survival of many species. The Act laid down procedures for declaring such areas and provided legal frameworks for their administration and protection, ensuring that these critical habitats received the highest degree of conservation focus. This was a significant step towards systematic habitat-focused wildlife conservation across the diverse Indian landscape. Another critical impetus for the Act was the urgent need to tackle the rampant illegal trade in wildlife and wildlife products. Items such as animal skins, ivory, horns, and bones fetched high prices in illicit international markets, fueling a sophisticated network of poachers and traders. The Wildlife Protection Act aimed to dismantle this trade by imposing strict prohibitions on the hunting of specified animals and the commerce involving their derivatives. It sought to create strong disincentives for those involved in wildlife crime through stringent penalties and enforcement mechanisms. This focus on curbing the commercial exploitation of wildlife was a vital component of the Act's protective strategy. The Act also recognized the importance of involving various stakeholders in wildlife conservation. It provided for the establishment of wildlife advisory boards at the state and central levels, tasked with advising the government on policy matters and the implementation of the Act. Furthermore, it created a hierarchy of wildlife officials, including chief wildlife wardens and wildlife wardens, empowering them with the authority to enforce the law, investigate offences, and manage protected areas. This institutional framework was designed to ensure a more organised and effective approach to wildlife protection, bringing a dedicated administrative structure to the cause of conservation. Section 6, Wildlife Protection Act 1972, Structures of Protection and Key Prohibitions. A cornerstone of the Wildlife Protection Act 1972 is its system of schedules which categorize different species based on their conservation status and the level of protection they require. Schedule 1 and Part 2 of Schedule 2 list animals that are accorded the highest degree of protection. Hunting these species is strictly prohibited, and offences involving them attract the most severe penalties. This prioritization ensures that the most vulnerable and endangered species receive maximum legal safeguards. Schedules 3 and 4 also list protected species, but with lesser penalties for violations. Schedule 5 lists animals classified as vermin, which may be hunted under specific conditions, while Schedule 6 provides protection to specified endemic plants from activities like uprooting and destructive collection. The Act clearly defines hunting in broad terms, encompassing not just the killing or capturing of an animal, but also activities like injuring, trapping, or attempting to do so. This comprehensive definition ensures that a wide range of harmful actions against wildlife are covered under its purview. While the general rule is a complete prohibition on hunting animals listed in Schedules 1 to 4, the Act does provide for certain exceptions. For instance, hunting may be permitted in self-defense, or if an animal becomes dangerous to human life or property, or for scientific research or management purposes, but only under strict authorization from the Chief Wildlife Warden. These exceptions are narrowly defined to prevent misuse. Beyond animal protection, the Wildlife Protection Act 1972 also includes provisions for the protection of specified plants, as mentioned in Schedule 6. This was a significant inclusion, recognizing that flora is as integral to biodiversity as fauna. The Act prohibits the willful picking, uprooting, damaging, destroying, acquiring, or collecting of these specified plants from any forest land or protected area except with permission. This measure aimed to safeguard rare and endangered plant species from overexploitation and habitat destruction. The Act thus promotes a more holistic view of conservation, encompassing both the animal and plant kingdoms within its protective ambit. A crucial aspect of the Act is its stringent control over trade and commerce in wild animals, animal articles, and trophies. It prohibits dealing in such items derived from scheduled animals, except under specific licenses and regulations. This is aimed at curbing the illegal wildlife trade, which is a major driver of poaching. The Act empowers authorities to seize illegal wildlife products and to prosecute offenders. By targeting the commercial incentives behind wildlife crime, the Act seeks to dismantle the networks that profit from the exploitation of endangered species. Its robust provisions against illegal trade have been vital in international efforts to combat wildlife trafficking originating from or passing through India. Section 7, the Water, Prevention and Control of Pollution Act 1974, Safeguarding Our Rivers and Lakes. The Water, Prevention and Control of Pollution Act of 1974 was a pioneering piece of legislation in India, specifically enacted to address the escalating problem of water pollution. As industries grew and urban centers expanded, untreated sewage and industrial effluents were increasingly discharged into rivers, lakes, and other water bodies, leading to severe contamination. This pollution posed significant threats to public health, aquatic ecosystems, and the availability of clean water for drinking, agriculture, and industry. The Act was, therefore, conceived with the primary objective of preventing and controlling water pollution and maintaining or restoring the wholesomeness of water across the nation. A fundamental aim of the Act was to establish a comprehensive framework for water quality management. This involved setting standards for the discharge of effluents and wastewater into water bodies. By defining permissible limits for various pollutants, the Act sought to regulate the activities of industries and local bodies that were major sources of water pollution. This standard-setting function was crucial for providing clear benchmarks for compliance and for enabling authorities to take action against polluters. The overarching goal was to ensure that water resources remained fit for their designated uses, whether for human consumption, irrigation, or supporting aquatic life, thereby protecting public health and the environment. The Act also focused on ensuring a clean and adequate supply of water for various societal needs. While its primary thrust was on pollution control, the underlying principle was the recognition of water as a vital and finite resource essential for life and development. By tackling pollution, the Act aimed to preserve the quality of available water sources, making them safer and more reliable for communities and ecosystems. This was particularly important in a country like India, where water scarcity and contamination often go hand in hand, creating complex challenges for resource management. The provision for clean water was thus an implicit yet critical objective driving the legislation. To achieve its objectives, the Water Act 1974 provided for the establishment of institutional mechanisms. The most significant among these was the creation of Central and State Pollution Control Boards, CPCB and SPCBs. These boards were entrusted with a wide range of powers and functions, including planning comprehensive programs for water pollution control, advising governments on related matters, setting effluent standards, and conducting inspections and investigations. The establishment of these dedicated bodies marked a significant step towards building institutional capacity for environmental regulation and enforcement in India, providing a focused approach to tackling the widespread issue of water contamination. Section 8, Water Act 1974, Mechanisms for Purity and Accountability. The pollution control boards, both at the central and state levels, are the linchpin of the Water Act's implementation strategy. The State Pollution Control Boards, SPCBs, are primarily responsible for executing the Act's provisions within their respective states. Their functions include surveying water bodies, laying down effluent standards for sewage and trade effluents, and evolving economical and reliable methods of treatment. They are also empowered to inspect industrial plants and sewage treatment facilities to ensure compliance. The Central Pollution Control Board, CPCB, plays a coordinating role, advising the central government, providing technical assistance to SPCBs, and resolving disputes between them, ensuring a degree of uniformity in approach across the country. A key regulatory feature of the Water Act is the consent mechanism. This requires industries and local bodies to obtain consent from the relevant SPCB before establishing any new operation or process, or making any new discharge of sewage or trade effluent into a water body. The SPCB, while granting consent, can stipulate conditions regarding the quality and quantity of effluent that can be discharged and the measures to be taken for its treatment. This prior approval system allows the boards to proactively manage pollution loads and ensure that potential polluters adhere to environmental norms from the outset. Failure to obtain consent or to comply with its conditions constitutes an offence under the Act. The Act empowers officials of the pollution control boards to take samples of water or effluent from any stream, well, or industrial outlet for analysis. This power is crucial for monitoring compliance with prescribed standards and for gathering evidence in cases of suspected pollution. The Act lays down specific procedures for sample collection and analysis to ensure fairness and admissibility of evidence in legal proceedings. If a sample is found to violate the standards, it can form the basis for prosecution. This provision for scientific monitoring and evidence collection strengthens the enforcement capabilities of the regulatory bodies, allowing them to act on a factual basis. Penalties for contravention of the Water Act's provisions are significant, including imprisonment and fines. For instance, discharging polluting matter into water bodies without consent or failing to comply with the directions of the pollution control boards can lead to stringent punitive measures. The Act also includes provisions for citizen suits, allowing individuals to initiate legal proceedings against polluters after giving due notice to the relevant authorities. These penalty clauses and citizen participation mechanisms are intended to create a strong deterrent effect and promote greater accountability among potential polluters, reinforcing the commitment to maintaining the wholesomeness of India's precious water resources. Section 9. conclusion, the enduring relevance of India's foundational environmental laws. The Forest Conservation Act of 1980, the Wildlife Protection Act of 1972, and the Water, Prevention and Control of Pollution Act of 1974 collectively represent a watershed moment in India's environmental governance. These big three laws laid the essential groundwork for a more structured and legally mandated approach to protecting the nation's natural heritage. They acknowledged the intrinsic value of forests, wildlife, and clean water, and established institutional frameworks to safeguard them from the pressures of unchecked development and exploitation. Their enactment signaled a growing national consciousness about the environment and the state's responsibility to act as its steward for present and future generations. Understanding these laws is profoundly important, not just for legal scholars or environmental activists, but for every citizen. They define the boundaries of permissible action concerning natural resources and provide avenues for redressal when these boundaries are breached. They have empowered communities, fueled public interest litigation, and shaped the discourse on sustainable development in India. The principles embedded within these statutes, such as the precautionary principle, the polluter pays principle, often reinforced through judicial interpretations, and the imperative of intergenerational equity, continue to inform environmental policy and jurisprudence in the country, demonstrating their lasting intellectual and practical impact. Despite their significance, the journey of these laws has been fraught with challenges. Effective implementation and enforcement remain persistent hurdles, often hampered by inadequate resources, institutional weaknesses, political pressures, and conflicts with developmental priorities. The sheer scale of India, its demographic pressures, and the complexities of its socio-economic landscape mean that the task of environmental protection is an ongoing struggle. However, these laws provide the critical legal tools and institutional mandates to continue this struggle. They have been amended over time to address emerging issues and strengthen their provisions, reflecting their dynamic nature and adaptability to evolving environmental realities. The ongoing impact of these foundational laws is undeniable. They have certainly helped to slow down the rate of deforestation, provide sanctuary to endangered species, and establish mechanisms to combat water pollution. Yet the environmental challenges facing India today, from climate change impacts and biodiversity loss to severe air and water contamination, are perhaps more acute than ever before. In this context, the spirit and letter of these pioneering legislations are more relevant than ever. They serve as a constant reminder of the delicate balance between human progress and ecological integrity, urging a continued commitment to the principles of conservation and sustainable living for the well-being of all.